there's talk that it's a classic example of a slap case, which is a frivolous lawsuit that's illegal, right? I mean, can you explain exactly what a slap is and what might come of that in this regard?
Sure. So a SLAP stands for Strategic Lawsuit Against Public Participation. It's basically a frivolous defamation or similar type of case that's brought against someone in order to silence them. So if someone is commenting on a political matter or commenting on a person in a way that is relevant to the public, but that the person who's being talked about just doesn't like, they might file a strategic lawsuit, a frivolous lawsuit against that person to try and get them to be quiet. The goal being bringing a lawsuit as an intimidation measure. Not everyone wants to go through the difficulty of defending a lawsuit, even if they know they're ultimately going to prevail.
You're claiming that is the defamation statement is that he said he had sex with your wife?
Yes.
Okay. And that's painted you in a false light?
It's caused tremendous pain in my life.
I'll get to that. We have to go through false light first. So does it paint you in a false light?
Yes, that my wife is cheating on me with Mr. Foreman.
But we all know that's not true, correct?
I don't know.
Did you not ask your wife? I'm just trying to understand. If you asked your wife, you don't believe her when she said no?
Wait, you don't know if your wife's cheating on you or not?
You want to go there?
No, I just want to ask that question because you said we don't know.
I've been with that woman since middle school.
But
I
you
would hope
just
she
threw
would.
her under the
But you know
bus.
what? Once somebody puts it out there for their fun and entertainment, it's out there. And it's a problem.
So it's something we cannot verify the truth of?
You mad now?
Is it a thing that can be verified, true or false?
Ask your client.
This guy it can't be very bright. If you're going to make the accusation that Afroman is defaming him by saying something false, how can you not prepare enough for the trial to simply sit there and say, no, he didn't have sex with her, it's a lie? Am I missing something here, or is that
incredibly You're not. Yeah, it's one of those things that, again, it's kind of on the cusp. If Afroman says something like that, does he mean it literally? That's what the jury is ultimately being asked to decide. Like, is he literally saying that this event transpired, that he slept with this officer's wife? Or is it more of just kind of a
talking trash, nobody takes it seriously kind of thing?
Exactly. Nobody takes it seriously, nobody's meant to take it seriously. Am I allowed to swear on this podcast? Is that a thing?
We encourage it. Go ahead.
All right, good. Yeah, the comparison I keep drawing to people is it's like calling someone a motherfucker. Like, Samuel L. Jackson is not out there accusing every single person, every villain in movies or whatever, of literally having intercourse with their mother. That's not what he's saying. It's a general insult. It's not meant to be taken as a literal statement of fact. And that's the kind of thing that we have in mind when you see statements like that.
To all units, proceed to your post assignments. All units, proceed to your post assignments.
That's the sound of the police. Whoop, whoop. That's the sound of the beast.
Yeah, baby. It's episode 24 of Probable Cause on March 24th, 2026. Jeff Norman and the FBI whistleblower himself, Greg Dillon, with you, as we always are on Tuesday nights. Hello, Greg. And we are pleased as punch to welcome as our special guest tonight, David Osborne, the winning, I emphasize winning attorney in the much talked about, very entertaining Afroman trial just concluded. And I was surprised to find out, chatting with David just a while ago, that this is only his second podcast. I thought for sure he'd be doing a whole bunch of them. So we have a almost exclusive. David is a former assistant prosecutor. He has a background in chemistry and history. I see Dr. David there. You have a PhD in something or other?
I hold a PhD in chemistry from the University of Georgia.
Wowie kazowie. So you have a life, a whole thing going on apart from Afroman. And I did a little digging, a little investigating about you, sir. And I am pleased to report that you have 5 stars on Google, 53 reviews. So it's not just like your 2 relatives or something. This is 53 people. One person gave you 3 stars. Yeah. And that person never hired you. That person was complaining, not really complaining, but mentioning that they haven't been able to get through to you. So I don't think anybody who has retained you and for whom you actually provided legal service has given you anything less than 5 stars. So I salute you, sir.
There has been a few people. I know there was a bad review on Avo, but it is what it is. I usually say look at the bad reviews and take them for what they're worth. And they were complaining about my coffee cup and my cats, and I'm like, well, if that's really what we're going to complain about, then okay, I'll earn that one.
Well, some people's mission in life is to find something to complain about, no matter how low or deep they have to go, it seems.
Well, we do have the 2 cats in the office, and I am notorious for walking around with my little uranium glass coffee cup and drinking out of.
So you aren't the stereotypical attorney at all. When you were saying something about the farm animals, I don't know if that was a joke or you really do have farm animals before.
No, I really do live on a farm. We have cows, ducks, the whole 9 yards.
David, if before we start, I'm just curious, how did Mr. Foreman find you? I mean, did he just make a cold call kind of a thing, or did you become aware of the case, and how did it work?
Well, technically, I was the 3rd attorney on the case. So originally, when the lawsuit was filed, Bruce Rivers had come on to represent Mr. Foreman. Where Bruce is not licensed in Ohio, he had to have a pretty much anchor attorney, and that was Tyler Cantrell at the law offices of Young and Caldwell. And so pretty much they were going on. Mr. Foreman had to reach out through a mutual party, and we sat down, talked about it, and he was kind of looking for someone more local who knew the officers to sort of respond, and I kind of fit that bill. Okay, so you obviously had some prior experience or interaction with the officers involved. I've known them most of my whole life. Oh, okay. Well, that gives you a step up, sure. Yeah, because
Somerville John. I'm sorry. What were you going to say?
Well, I was going to say technically, I went to school here. I graduated, came back. So I've known Mike my whole life. I've known all of them my whole life. Okay, all right.
Somerville John, one of our regulars, one of our favorites, says, "What or who is Afroman?" John, have you been living in a cave? All right, for the benefit of Somerville John or anybody else who doesn't know, David, you want to kind of give a little summary of what this whole controversy is about? I can't believe he hasn't seen this in the news.
So, Mr. Foreman, or as his stage name's Afroman, his first claim to fame was because I got high. And so I remember listening to that when I was younger. I think we all remember it. And so he kind of faded away. So there was a raid of his house under a search warrant in August of 2022. Officers went through everything, searched behind the couch, under the hood of the car. I mean, you name it, they looked there. And they found a little bit of weed, big surprise. And they found some money of his. There was some damage because they had to breach the door. So they beat the door in. They damaged the closet and everything, looking for secret compartments and everything. Ultimately, they never found anything. No charges were pressed. A short time later, Mr. Foreman gets back his money. The money on the search warrant return, and what is given back is different by about $400. One pile's $390, one pile's $10. And so Joe, being the musician, does what he does. Made a music video. The first one was Lemon Pound Cake, where he takes surveillance footage of them in the house from his own security camera system and starts pretty much making a nice video, because one of the officers, as he's walking by the island in the kitchen, kind of glances or appears to glance at a lemon pound cake there.
A double take.
Let me play a few seconds of that video. So basically, he made a few videos mocking the police about this incident. So here's a little bit of the pound cake video.
They found no kidnapping victims, just some lemon pound cake. Mama's lemon pound cake. It tastes so nice. It made the sheriff wanna put down his gun and cut him a slice. Of what? Lemon pound cake. He wanna put
What a great tune. Okay, sorry to interrupt, but I
It's
thought
the
that
perfect where you're seeing him sort of like almost glance at it.
Yeah.
And then that song was followed up by two more. One is why you about breaking down the door, and then another one which is why are you disconnecting my security camera? Basically taking his footage and what happened and making a criticism and kind of fun of the police. He did some posts on Facebook, Instagram, and everything. Eventually, that culminated in the officers in March of 23 filing a lawsuit against him, and it started in 23. From there, Bruce came on, so did Tyler. They did a judgment on the pleadings. Eventually, that tossed out 2 of 5 claims. Basically, they had started out suing for 2 claims in reference to using their likeness, and then 2 claims, false light, and then publicity to private life, and then defamation. The judge, Jerry McBride, determined they were public officials, tossed the first 2 claims, so there was no question about them and their image. From there, we went forward on the last 3 claims. We went through depositions. A counterclaim was filed for the damage to the door, the missing money. Eventually, all that goes through. Judge Jerry McBride withdraws due to his health. We get Judge Hine appointed. Judge Hine then pretty much tosses all the counterclaims and then moves us forward with the 3 claims on the plaintiff side. Plaintiffs got rid of the false light to private life. They got rid of that, so we went forward on just defamation and false light. They also dismissed another defendant because they had sued Media Access, I believe it was, or some music company, and they didn't really do anything, and so they dismissed them at trial too, going forward solely against Mr. Foreman. And we had I still can't believe it. We had a trial.
I forgot to mention in the opening video, that was David Carey, who's the managing legal director of the ACLU of Ohio, and he submitted an amicus brief, or maybe an amicus brief. What was the other pronunciation?
Oh, I forget. He had a third, and it was even.
How do you
more
say it, David?
rare.
It's an amicus.
Amicus, yeah, an amicus brief, right? Anyway, so we interviewed him yesterday, and we recorded it, and so that was some of that in our opening. When we're done here live tonight, we'll show some more of that recorded interview with David Carey, the other David. So he was saying that at first he viewed it as a slap, the frivolous lawsuit where you're allowed to recover your costs and so forth, and then he's not so emphatic about that anymore because the amended complaint got better. They actually specified allegations of making false claims. So he's saying, well, it's at least meritless, but maybe not a slap. What's your feeling on that?
I think it was a slap, definitely, from the beginning. I mean, it was brought for only one reason, and we see that through the depositions. We see that through the testimony at trial. So I got no doubt that's why they brought it. It fits the definition. At the time they brought it, Ohio did not have a statute to that effect, and that statute went into effect in April of 2025. So today the law is vastly different than what we were under at the time the case started. So,
David, I had one quick question. When you said it went to trial, was it a jury trial or a trial before the judge?
Oh no, this was a jury trial. I'm a firm believer you have a jury trial. You don't try things to the judge unless it's extremely technical and you're afraid you're going to go over the jury's head.
Yep. Okay.
Now, I haven't seen that much of the trial, but I see a lot of comments online and people really complaining about the judge, saying that he was biased against your side. Was that how you feel about it too, or what? You may have to go before him again. Do you have to watch what you say?
No, I don't. I hope I never have to go before Jonathan Hine. It is one of those that I've never had a trial like that. I've never experienced that from a judge before to that degree. I don't know if he's biased or not, or if he just run his courtroom differently, but it was definitely not what I was used to.
Right. Now, another thing that's very unusual is that the winner doesn't normally have to pay court costs. The loser has to pay. But in this case, he said that your side, and it's not that much money, but it's the principle that matters here. For some reason, he decided that your side, the winning side, has to pay half of the court costs. How unusual is that?
I've never seen that before in a civil case. I've seen it in divorces, but that's kind of standard there. I've never seen it in any civil case I have ever defended or even prosecuted. I've never seen it. And so it's something I am still researching because I'm curious if there's a test out there, if there's a criteria, just what the case law is. But we're still looking into that because it's something I've never seen. So I want to learn about it.
David, is that subject to appeal?
It depends on what the case law research and everything shows. It could be depending on what that shows.
Yeah. Well, yeah, the law does matter, of course, but just intuitively, it seems ridiculous. I don't know how much intuition counts in the judiciary, but that's my immediate reaction. It seems crazy. You won.
In this kind of case, it seems strange. I could understand if we tried it to the judge and the judge said, hey, I've listened to both sides. Get the hell out of here. I could see that, yes, but this is not that kind of case. Right. And I'm sorry if I do cuss. I have a horrible problem with that, and I'm trying to control it.
Oh, no, not at all. In fact, in the opening, David Carey asked if it's okay to cuss, and it certainly is, especially since it's relevant to this case. He gave, as an analogy, the word motherfucker as a means of explaining why it's not really defamation when Afroman says, one of the cops is a pedophile. I don't know what else he was saying. I can't remember, but he was saying, it's like if you call somebody a motherfucker, you're not actually saying that he had intercourse with his own mother, and nobody takes it that way. So I don't know if that's a phrase he coined himself or if that's like a legal term, but you know what he means, that it's kind of like motherfucker? Well,
a lot of it's supposed to be the reasonable person standard. If you say this, will a reasonable person interpret it that way? And that's exactly what it is. When you're sitting there yelling at someone and calling them a motherfucker, you are not making a statement of fact. You are expressing your opinion in a very nasty way. Yeah. But it's not something that anyone's going to take as a literal fact.
Right. So after the show yesterday, Greg and I were kind of laughing about how I've always been amused by this when, you have people in the courtroom who are, apparently, very conservative, polite people, but there's testimony that's extremely vulgar. And I always find it kind of amusing to watch, some little old lady stenographer or, somebody who's very polite and conservative have to hear that or even say that. And then I was watching some of the videos today, and I saw that when you were interviewing, I think it was the ex-wife of one of the cops, and you asked her if she was familiar with the song Wet Ass Pussy. And you said, well, you only want to say it once, but let's play that clip.
I'm going to give you the complete song and then summarize it because I only want to say it once. Are you familiar with the song Wet Ass Pussy?
Yes.
Is that a rap song?
It is.
Has your students played it in class?
Once, and I asked them to please turn it off.
When they were listening to it, did they think that was fact?
No.
So they didn't think that was depicting anything in real life?
No.
Why did you do that to that nice woman, wet ass pussy? She's not accustomed to such a language. No, seriously, why did you ask that question?
So that actually is more important than people think, because I was trying to illustrate the reasonable person standard. Mm-hmm. If a teenager knows it's not true or would not take it that way, no reasonable adult could. And so that's really what I was getting at with it.
Jeff, just for the audience, could you just explain who that witness was?
Let David explain, because
I'm sorry. Yeah,
I think it's the ex-wife of one of the cops, right?
Yeah, our single witness was Sean Grooms' ex-wife, Rhonda Grooms. They had gotten a divorce, and so we had called her as a witness because she was I had interviewed her and she was able to tell us what happened. I mean, she would have lived through all this stuff. So she would have been very pertinent to tell us, okay, yeah, I had these things. I remember the phone calls. I hated it. And so that's where we were bringing her in basically to show that he was full of crap.
So this is another version of the motherfucker theory, right? Just as you don't take motherfucker literally, you don't take wet ass pussy.
That is correct. Yes.
Right. All right. Let's see if we can come up with as many excuses as possible to say vulgar words in the context of discussing the law.
According to some of the people I went to law school with, I've checked every box they could ever check in a trial. So.
Well, speaking of vulgar, here this actually is relevant. And no swear words, but it's kind of disgusting. The whole reason this happened is because there was a confidential informant who told the police that some strange things were going on at Afroman's house, including that he's possessing drugs, selling drugs, kidnapping people, keeping women locked up in a dungeon in his basement where they have to urinate and defecate in a bucket if they upset or disobey him. And then it turns out that he doesn't even have a basement in his house, let alone a dungeon with all this other stuff going on. So what can you tell us about this confidential informant? Was there any reason? How hard did you look? We were talking about this with David Carey, the other attorney, but this wasn't really his case. So I think you can probably tell us a little bit more. Did you look at what kind of a test or whatever the cop subjected him to determine whether or not, I don't know if it was a he or a she, whomever this informant was, whether it was a she, whether or not she was reliable?
So in the deposition, we actually go through that in the depositions. And you'll have to forgive me because it's been a while. So I'm doing some of this from memory. So if I'm a little off, it's in the deposition. But we do actually go through that in the deposition, I believe, with Mr. Newland, because he talks about how he corroborated enough to sort of show she was telling the truth. But I think the corroboration was more just descriptions of the house, description of what the kitchen looked like. Nothing substantive is what I would call it.
Right. David, I'm just curious. Did the informant, how did she qualify that information? Was it through direct observation? Was it from gossip? Was it, hearsay? Was it third hand? I mean, how did that information get that far in, without additional scrutiny to it?
So it's my understanding that Mr. Newland had been in Mr. Foreman's house previously in the kitchen. And so he was using his memory of what the kitchen looked like to confirm whether she had been in the kitchen. And so it's my understanding that's from the depositions, that's how he, I don't want to say confirmed because it's all crap.
I mean, I don't want to nitpick, but the thing is, if somebody,
this deserves a lot of nitpicking, I would say.
If I had a CI and they said this person has a dungeon in the basement, I mean, my first question is going to be, have you seen this dungeon? And if you have, give me as much detail about it as you possibly can. Are there chains? Are there handcuffs? Is it rope? Is it, soundproof? I mean, flesh it out so that I can write with some authority on this. But if you say that someone has a sex dungeon and leave it at that, just seems to be such an irresponsible approach.
It does seem weird. I mean, when I read the search warrant for the first time, I was like, is someone just taking a scene out of 50 Shades of Grey or something? I mean, it doesn't read like you would a normal search warrant. I mean, usually they're very detailed. Yeah. Such and such was chained to the wall. Such and such is seen like this. I mean, it's extremely detailed. In this, it's like the search warrant, which I reach for here, but it's like, I think she says in here, the confidential informant says, though, she hasn't been there for over a month. Which, if you have kidnapping victims, you would.
Yeah.
That's a long time to wait before you report somebody who's been kidnapped.
No, but again, I'm just curious: was it information that she had learned and was passing along, or was it because
Yeah, what was her claim? What was her specific claim? That she had actually witnessed this dungeon, or she had learned about it?
Let me back up and give some context to how she started talking to the cops. That may help some. So the officers had gotten a tip of a lady having a large quantity of marijuana. They did a knock and talk on her. She admits to having the marijuana, shows them the marijuana. They take it into evidence. At that point, they ask her to go back to the police station, make a statement. She goes to the police station voluntarily, drives herself, and makes a statement to Mr. Newland, which is the basis for the search warrant. And from there, that recording fails. It does not record that interview. So he sends Mr. Newland, while he's typing it up, sends in 2 other officers to talk with her again, which is Mike Estep and Sean Cooley. And they get a completely different story. I mean, so she tells Brian Newland, "Oh yeah, I'm holding all this marijuana for Afroman." Well, you get the other 2 officers in there, and under depositions, they said, no, she told us that she stole it from him. And so basically, when you look at the search warrant, it looks like all the positive or anything that would lead to the cops is left in there, and anything that contradicts is taken out. So it really is a weird search warrant.
Yeah.
But I mean, doesn't that become exculpatory evidence that they are obligated to provide?
If we had gone to a criminal matter, yes. In
Okay.
the civil matter, this is slightly different. But the key thing I was going on when I was trying to save the counterclaims is that it's basically a mission. And so, the judge can make a decision, but if you don't tell the judge all the facts, he's making a decision, but it's based only on what you said. And under Ohio law, you do not have immunity if you leave something out of a search warrant that is relevant. And I thought that the idea that she changed her story within a short time was extremely relevant. Especially the fact that she had a criminal record and all that, because Mr. Newland testified that they had a CI packet they completed, and they completed the packet. As part of the packet, they run your criminal background. They pull together everything to actually determine if you're trying to tell the truth. And this is one where, of course, also the question would be would you be making up the story to get out of your own felony? Because as far as I know, she was never charged out of the possession of the marijuana either.
Wow, that's very unusual. Well, I mean, I can't compare Connecticut to Ohio, but that would be highly unusual to go that route. I mean, in my experience has been, the charges are pending and can be later, adjudicated favorably or outright dismissed, but you don't just not charge because you have someone who's working with you. But every place is different, I guess.
Is pot legal in Ohio or not?
It is now. At the time, it would have been a minor misdemeanor.
But they didn't slap Afroman with a misdemeanor charge for
the more important question is, how many search warrants have they done for marijuana? And even Mike Estep said in his whole career, they've only done 2 or 3.
But isn't there must be a weight limit on what's legal and illegal? No, or not?
There is, to a point, yes. I want to say, give me a second here. I'm looking.
Yeah, but he said at that time it wasn't legal at all.
So, like, what they found with the confidential informant was 2,131 grams of marijuana was taken from her, which would have been a felony 5, level.
Right. No, I'm not sure I understood your answer, David. What I'm getting at is, given that the cops had all this hostility towards Afroman, why wasn't he charged with a misdemeanor, at least for the marijuana?
He would have been charged with a minor misdemeanor. All he could have been done was fined up to $150.
Oh, like a parking ticket or something like that.
Actually, I think a parking ticket probably gets you
more
more
expensive.
Well, that's worse, because at least you were harming somebody else. So taking away parking space from somebody. Wow, this is wild.
Yeah,
so, I mean that's why when you talk about charging, I mean there's not really much that could come out of it for that.
Yeah,
I mean,
but David, I don't want to get fixated on it, but I'm still curious. Did the informant say she had seen this sex dungeon, or she had just heard of it?
Well, let me, if you don't mind me taking a look here.
No, go ahead and read. We'll talk amongst ourselves while you read. Because no, I think it's worth. You're making a good point there, Greg. Because the fact that there was no basement in and of itself makes it pretty obvious this was not a reliable informant.
Right.
And I'm going to ask David the same question I asked the other David. He may not know either, because this is all lawyers don't know every area of law where they don't have experience. But I'll wait. Go ahead.
Yeah, the part I read here is confidential informant number 1 further stated Afroman has a basement referred to as the dungeon in which he, being Afroman, keeps women locked in, and then it goes on as we talked about. But that's the only reference to it.
Wow. That is
did any of the mocker did any of the videos that Afroman mock the confidential informant? I'm thinking.
I think some of the newer ones did. I'm not sure if I don't think any of the old ones did. No.
I get he's writing songs and he has to pick whatever works that's amusing and entertaining and all that. But on strictly a fairness level, I'm not sure these particular cops all deserve the blame. I would imagine, maybe you would know, Greg, isn't there one cop who makes a decision about whether or not they're going to ask for a warrant? And if so, that person probably deserves to be mocked.
Yeah, well,
and maybe the judge who issued the warrant deserves to be mocked, right?
Well, in Connecticut, it's sort of odd because if I want an arrest warrant for you, I can file an affidavit. If I want a search warrant for your place, I need a second co-affiant. So I'm only going by what I've experienced, but it would be you would need two investigators to submit a sort of a mutual affidavit alleging whatever the facts were in the case. But the onus would certainly fall on the preparer of the affidavit as to the credibility of the informant.
Right. David, have you had any reason or opportunity to look into what it would take to get the identity of the informant disclosed and to hold that person accountable? If hypothetically, I'm not saying this is the case, but if hypothetically there were to be an accusation that this person was lying intentionally, and which of course they would deserve to be punished for that. Have you had a chance to look into how that might work?
We have a general idea who the CI is. I mean, we're pretty much 99% sure. I want to say it actually comes out in depositions who it is, because we did research. That was one of the big things we did. We researched everything, looked into it, and we looked into her criminal record. I mean, we pretty much rebuilt who the CI was.
Right. I mean, she may be a person who has no money and there's nothing to be gained by suing her, but I'm just very interested in whether or not somebody can be held accountable for something like this, because if not, it seems like a ridiculously easy way to ruin somebody's life, to just call up the police and say, hey, David Osborne has got women defecating in a bucket in his basement. See ya.
It's kind of funny you mention that, because actually, if you read in the deposition, I actually kind of make a point that I say, would you raid my farm if someone just says that I have a sex dungeon?
Right.
Or something to that effect. And they actually answer no in that case, which is interesting, because what's the difference between Mr. Foreman's house and my farm other than the cows?
Well, was it because was it because of his reputation as being sort of an advocate to a degree of marijuana? Would that be part of it, you think? Or
I wouldn't see so, because I mean, marijuana, even in 22, marijuana was not really becoming an important thing. We were moving away from it. I know I was a prosecutor. It was one of those things. We had people do classes and then we'd just have them pay court costs. I mean, it was not something that we were actively, I mean, yes, we were prosecuting, but it wasn't like it was rape cases. It wasn't like it was the most.
No, but I mean, like in Connecticut, I mean, even though it's legal, if someone is suspected of trafficking, they'll make it more of a high priority than obviously the recreational user. And I'm just wondering if they thought he met the requirements or the title of a marijuana trafficker. I thought maybe that might be the difference.
It would seem to be that they were getting there, because there is a line in here confidential informant number 1 continued to state she routinely traveled the United States with Afroman to concerts and marijuana dispensaries where they would obtain large amounts of marijuana and transport back. But she actually doesn't say he's selling it. She just says that seems to be a statement. Yeah, he goes to a dispensary and gets marijuana and travels back with it. So, I mean, I guess that would be the part that would go to what you're saying, but
they don't connect.
It's not well spelled out.
Yeah, they don't. They never connect the dots.
No, it's not well spelled out. It should be. You would think it would be articulated, especially to meet each one of the elements of what you're alleging as criminal conduct.
Agree. Yeah.
I want to play another clip from the trial and ask you about it and compare it to what we saw in the opening video, which was a cop who seems to be almost too dumb to be believable, who was claiming that, Afroman defamed him by falsely claiming that he had sex with his wife meaning the cop's wife. But then when he was on the witness stand, he was like, I don't know if he did or not. He didn't even have enough sense to say that it didn't happen, because how could it be a false statement if he doesn't even know whether or not it happened? So that was really stupid. And I think we all agreed on that last night. I don't know if you have a different take on that. But here's a much different reaction, actually the opposite. Another cop, Lisa somebody, I forget her last name.
Lisa, yes.
Yeah, she was crying, which, I don't know if she was acting or if it's real tears or not, but at least, if you're going to make it seem like you want damages, you should look like you're actually harmed. And she did exactly that. So let's take a look at that before we comment on it.
You really don't know her. I noticed her voice is a few octaves lower. She's not too ugly. She's not too fine, but she's might whip out something that's bigger than mine. Lick 'em love, Lisa. Lick 'em love, Lisa.
So they're playing this song in court.
They played all 13, 14 minutes of it.
Yeah, I won't play that much, but just to give you a taste of it. And Afroman's just like grooving to the tune, and she's sobbing. So I guess she was sobbing. I don't know what the lyrics are, but is that? Can you explain why she might have been so upset?
Well, so
or what she was claiming.
The song that he was playing, which is about 13, 14 minutes long, was playing on the idea that she was a lesbian, and so that's what was upsetting about it. And so there was very distasteful parts that the plaintiff played that would have tended to support that.
And did you say the song is 13, 14 minutes long?
Mm-hmm.
That's even longer than American Pie or Hey Jude.
Stairway to Heaven.
Mm-hmm.
Alice's Restaurant.
Word on that one. But no,
and they played the whole thing in the court?
Yep. Mr. Klingler did play the whole thing while she was on the stand.
Oh, maybe that's why she was crying. At a certain point, it's just torture.
Well, that's really what it looks like, is that, I mean, there's a tasteful way. If you know your client is sensitive to it, there's a tasteful way to do it, not break him down on the stand. But it did appear that he played the whole thing. She had to sit there, listen to it, and answer questions, and she was just breaking down, crying on it.
And she's upset because she was portrayed as a lesbian, which I guess maybe that in and of itself, I'm guessing, isn't what upset her, because probably people were then mocking her as being a lesbian too. Is that
my understanding? She was saying that people would yell like "Lick 'em low, Lisa" as she went by.
Lick 'em low, Lisa. Is that what you said?
Mm-hmm.
Okay.
That was the name. Scooter, stop it. That's the cat. Sorry, you gotta forget the cat.
No problem.
But yeah, she would say, and she testified that people would drive by, yell, "Lick 'em low, Lisa." Some people would ask her if she had a penis, different things like that, a sex change surgery and stuff. So it was really.
Greg, if somebody called you a lesbian, would you burst into tears? Well, maybe. How about if it was in a song for 13 minutes? Would you burst into tears?
If I had to listen to the 13 minutes of that song, I might start crying. Yeah.
Wow, that is a long song. All right. So what's the next move for you, David, with this case? I think before we came on, you said there may be an appeal.
There's some question. I know Mr. Klingler had requested some information of the court. He put in an email requesting stuff about jury selection. And so you tend to do that if you're looking at an appeal. So far, no appeal has been filed. No official documents have been filed. Just the kind of investigation to it. From my side, I'm looking into the fee cost thing to see what the law is on that, because that may be something to appeal. And it may be a question to ask about that if there is a test, but we got to see what the case law says before you do anything.
Yeah, on principle, on principle, if nothing else, you guys shouldn't have to pay a penny.
Well, it's one of those things I've even questioned. Maybe we should have a test for it. Maybe that's what comes out of it. If there is no case law, maybe the court says, hey, these are the elements you look at. Sometimes you appeal things just to get some issue clarified. I mean, I just went sideways.
Yes, you did. Is there? You don't know why that happened? It just happened all by itself? Can you turn?
Well, I think we can all say from what we've seen in court, I cannot operate technology. I didn't touch this.
Oh. But is there a device that you could turn?
Annie, can you help me?
Well, we all have to go like this. That's all.
Yeah.
But no, you got to look into that. I know anything appealed would be technical errors. You want me to rotate the whole thing?
No.
Well,
we only got 2 minutes left.
Yeah. There you go.
Here we go.
That's okay. See?
Well, thank you. It was that easy. Okay, well.
Self-corrected.
You're more competent than you thought. So I think
she
maybe
it was behind the screen doing it. So.
Oh, okay. I didn't realize that. Thank you to whomever did that.
That was my wife Annie helping me here.
So maybe there's another video that should be made to mock that judge. And you know what else Afroman should do? Who else he should mock in a video? Is the guy who gave you only 3 stars on Google review.
Well, that doesn't bother me at all.
All right, I'm sure.
I don't keep a website. I tell everybody our reputation precedes us. I mean, if you come into our office, we promise that we're going to fight, and we promise we'll be prepared. Other than that, we don't make any promises, and we know the people come to us for a reason, and most of them keep coming back because we keep our job. And it's like,
there it is, 5 stars. And don't call him. He doesn't need the business. Leave him alone. Don't harass him. Will you hang out?
We were doing good.
If you don't have to go, we have a segment we do called Has It Happened to Greg? We have 3 videos of police encounters, different ones each episode, and we talk about it. Since you're a lawyer, you could probably weigh in on it. Can you hang out for a few more minutes?
I got no problem at all.
All right, great. Let's do it. All right. The first one is a little, as so often happens, a minor traffic situation that turns into something more. Somebody didn't want to accept the ticket. She threw it out the window, and watch what happens.
Stop! No, stop, please, I'm scared.
Thompson's attorney, Lee Merritt, says his client was driving home to Melissa with her 15-year-old son when she was pulled over for speeding while passing through Hearst.
She wasn't happy that she was being pulled over. She did not believe she was speeding. She suspected that she may have been the target of racial profiling.
After arguing back and forth, an officer issues her a citation. She refuses to take it. The officer then tosses it into her car, and then Thompson throws the citation back out the window. The officer tells her that's littering, and that's when the situation escalates. Thompson tries to roll up the window, and the officer grabs her by the arm while repeatedly asking her to get out of the car. Thompson refused repeatedly before she was dragged out as her son watched.
The message that this kind of arrest and brutality sends to the community, especially when it's been ratified by the Hearst Police Department itself, is that if you don't respect a police officer, if you don't show them deference, if you don't kowtow to them, then they will brutalize you with impunity.
CBS News Texas requested an interview with the Hearst Police Department about the incident, but the department declined, sending us this statement instead, which reads in part, A formal complaint was filed on January 20th, 2026, claiming excessive use of force, and an internal affairs investigation was opened. A thorough investigation was conducted. The claims submitted were determined to be unfounded, and the internal affairs investigation was closed. The department added that the Tarrant County District Attorney's Office is continuing to investigate the case. We'll keep you updated as the story develops.
All right, where should we start? Does she have to accept the ticket? Is that a requirement?
No, just this is. I have a complete. My whole thing is this is what I hate about new officers. You look at the old officers; they would have said they would just left it on the ground and kept going, because when she fails to show up at her court date, it'll take care of itself. I mean, that didn't have to happen.
Okay.
That happened to me one time, Jeff.
Yeah, somebody threw it out, the same kind of thing?
They tore it in half and tossed it out the window. And I said, well, no, we have two options. I can write you an additional infraction for littering, or you can get out and pick up both pieces. And they got out and picked up both pieces. So that was it.
Because I seem to recall that when people get a ticket, they're asked to sign it.
It depends if it's an infraction or a misdemeanor in Connecticut.
Uh-huh.
A misdemeanor, you have to sign it to acknowledge that you're going to appear in court, because it's technically an arrestable custody offense.
Okay.
But if it's infraction,
you don't have to sign, but they ask you to sign it, and but you don't.
Usually to acknowledge that you received your copy. That's all the reason is for it.
Okay, so it's not required by law, so there's nothing to do about that. The only issue is this major offense of littering. So what do you think about it? Well, you did the same thing, so maybe you're in favor of it.
No, I did the same thing, but I was not going to pull somebody out of the car if they didn't pick it up. I was going to write them a second ticket.
Right. All right, so I get what you're saying, Dave, and I agree. It's not a big deal, and would be.
Well, I know in Ohio, if you don't want to sign, that's fine. The officer just writes refused on it and goes on.
And that's all those, right.
But David, my understanding, at least in Connecticut, would be if it's a misdemeanor offense, like say reckless operation, they have to sign it because that is their written promise to appear for the offense. And then if they don't, well, in Connecticut, we used to have the option of saying, well, if you don't sign, you're not admitting guilt by signing. You're admitting that you're promising to appear. If you're not going to sign it, then you are going to come into the station and post a bond.
We've had it OVIs marked refused where they refuse to sign them.
I guess it varies from state to state.
All right, so I get that we're not thrilled with the fact that he made an issue out of a littering, but given that he did, what about the physically removing her from the car in any way, shape, or form, and also the way he did it? Too much force? Grabbing her by the neck, sort of?
Well, I mean, she always had the option of undoing her seatbelt and getting out of the car. I mean, right. I understand maybe his behavior might be over the top, but let's not take away any responsibility on her part. Obey, and then
what happened to your audio? I wonder if that's. Can you say something, Greg?
Yeah.
Oh.
Can you hear me?
Yeah, but when the video was playing, I couldn't hear you.
It's like he's in a tin can.
Yeah, I know. It shouldn't have mattered because I didn't even have the volume up. Okay.
Okay.
All right, go. What were you saying?
No, I just said you can't completely exonerate her for not obeying or complying with anything. The easy thing to do is, okay, I'll get out of the car. I mean, that's it. Then it's kind of over.
Okay. But still, we can evaluate the manner in which he removed her.
No, I understand, but I'm saying
well, it's a question. But what's your answer? What's your answer, though? Was it undue force or not? Excessive force?
I don't think it was excessive force. But again, she has the option of cooperating and then filing a complaint when she gets home for excessive force or unreasonable motor vehicle stop or whatever she wants to complain about. But to fight with the officer is never going to be a great idea. Yeah, he's not going to give up. So, I mean, I don't understand where she thinks it's going to go.
All right. Let's move on to the next video.
Well, I will say
David's here. What's that?
That is one of the things I keep telling everybody. I mean, if you don't agree with the officer, don't fight him. That's what we do in court. That's why you get an attorney, walks in there, and but it is one of those things where she may have felt like she's right, but she made it worse.
Yeah.
But you go to court, we can take care of that in court.
Fight it later. Fight it later.
Now, fight it in the correct place, which is in the court, not at the scene of the crime.
Right. Okay, I agree. Good advice. All right, so this is your new specialty, David, a celebrity situation. Okay. This was Justin Timberlake getting pulled over for DUI.
Stops because you keep veering off to the left, and then you're not stopping at the stop signs.
Yeah, sorry about that.
Is this your vehicle? Whose vehicle is it?
Yeah, it's just a rental.
It's a rental? Okay. Do you have any registration with it? Do you know if they can put it in the glove box?
Let me check.
What are you visiting?
Yeah, I'm on tour.
What are you doing?
I'm on a world tour.
A what?
A world tour.
Doing what?
Hard to explain.
No, it's very easy to explain.
Yeah.
A world tour. I'm Justin Timberlake.
What's your name?
Justin Timberlake.
You are Justin Timberlake?
Yeah.
You have a license with you?
Yeah, I do.
And then you're going to put your right foot in front of your left, stay just like that. Okay? You're going to be heel to toe, like this. Heel to toe. So the way this device works, you just put your lips over it, and you blow into it like you're blowing a balloon. No?
Yeah.
Okay. All right. At this point, based upon the observations, you're under the arrest for suspicion of driving while intoxicated.
There has to be a moment of talking.
No. Not anymore.
Please help me!
Not anymore.
Hold on.
Okay.
So,
Hold on.
This is the registration of the vehicle. Just make sure it stays with the vehicle, okay?
I have his phone.
Yeah.
Yep.
Can you guys please just do me a favor, because you loved bye or
I'm
like
happy.
sexy back.
So,
like, do me one favor. Let me ask him if he wants me to give him his phone.
Yeah. I mean,
This is insane.
So it's not going to be a long thing. I'll let you walk up real quick.
Please.
Okay, so that woman was obviously in the car with him. So the first thing, it's pretty weird that he was stymied by the question, what are you on tour for? I think music would have been a one-word answer that might have worked.
It wasn't a trick question, I don't think.
Yeah, or I'm a singer, if you want to go to the three-word answer, but...
Well, the officer was doing a divided attention test. The idea is he had asked him to get something, so he should have been getting that and answering the question. So he's doing a divided attention. I mean, the investigation was already started as soon as he stepped up there, and that's what my prosecutor brain's ticking off. Okay, investigating for this. We see signs of impairment. So usually that's what the officer does on an OVI. You come up to the officer, and the officer comes up, goes, da-da-da. How are you doing? License, registration. You're reaching them, and they start talking with you. It's to see if you can do two things at once because, well, I mean, if you're driving a car, you're looking at your surroundings, you're looking at the pedals. That's part of, under Ohio law, that would be part of your impairment.
Oh, that makes sense. So it was just too much for him to handle, that extra issue of why are you on tour?
Well, I mean, he should have had an answer for that. And if you think about it, you should be able to sit there and be, okay, I'm getting the registration, all the paperwork out here, and you're telling about the tour and how, you just sung in Colorado or wherever. I mean, that's what he would expect. And so that's why you start seeing him pull out of the car. I mean, obviously your first basis would be the odor of some kind of alcoholic beverage or something.
Right.
I don't know why he was pulled over, but I assume that was it. But let's say that was it. That's your starting point. They're going to ask you more questions. Your reactions are going to determine whether they pull you out of the car. And you can see slow response. You can see divided attention's gone. And you can even see, he asks him a question, he completely forgets about the registration. And so he was going to be pulled out of that car to do field sobriety tests,
right?
Because he was showing all the signs.
Right. But he didn't pull like, special treatment celebrity thing. He was, respectful and mellow the whole time. Mm-hmm. His friend was a little bit, do you know who this is kind of thing? Give us a break because you're a fan of these songs. I would have never even heard of those songs. But you know what? There's another weird aspect to this, and that is that Justin Timberlake filed a lawsuit to prevent the footage from being released, and then there was some kind of settlement about releasing some of it, but not all of it. And I've never heard of such a thing. I always thought that if it's a police matter and it's, you know, it's a public thing, then it's going to be released. In fact, we were talking about this when we did that segment about the girls who like take off their clothes when they get tickets, you know, to try to get the cop to be lenient with them and so forth. And they're very embarrassed that these YouTube channels where they're all out there, and nothing ever came up about how they had any legal right to prevent it. But here we have Justin Timberlake actually having some success to keep some of it from being released.
They don't have Mr. Timberlake's resources.
Well, yeah, but I mean, he has the money to hire a lawyer, but still the question is, what is the legal basis for it? Are either of you familiar with what might prevent the footage from coming out?
Well, under Ohio law, you'd be looking for, is the victim identified? Because Marcy's law would say the victim would be taken out. Maybe there's an ongoing investigation. You want to clip that. But for the most part, most of the video is in because it's a public record.
Yeah. So that's the part that I'm really curious about.
Well, the footage of him in at the police station, he has no expectation of privacy there. And a motor vehicle stop on a public highway, there's no expectation of privacy. So I don't know what grounds he has other than the fact that he's embarrassed by it.
Yeah, I think that's what he was arguing.
Well, I would say every person pulled over for OVI is embarrassed.
Of course.
Yeah. All right. Well, so you ever pull over a celebrity, Greg? Connecticut doesn't have a lot of celebrities, but
well,
except when Frank Serpico comes to testify at your trial. When they go to one of those pizza joints in New Haven.
We had Richard Gere that was living in town at one point for a summer. One of the islands was purchased by Gary Trudeau, who used to do the Doonesbury comic strip, and I think his wife was a TV newscaster. I forget who his wife was. But no, I didn't have any personal interaction with any of those people.
All right. Yeah. All right. We have one more, and this is Jazzy Crockett. Some call her Jasmine Crockett. Her former bodyguard got into some trouble. I'm having trouble finding it. Where is it?
Trouble, I think, is kind of a mild term for what happened.
That's true, but much like Justin Timberlake, I couldn't concentrate because I was also focusing on trying to find the video. All right, here it is.
New video of Democratic Congresswoman Jasmine Crockett's bodyguard. In police body cam, you can see the parking garage showdown ending with a Dallas SWAT team shooting the head of her security.
Hey, stop the car! Stop the car!
It's the dramatic police chase through downtown Dallas involving Texas Congresswoman Jasmine Crockett's bodyguard. 39-year-old Mike King was living a double life, a federal fugitive who posed as a cop and also worked as a top security guy for the nationally prominent Democrat.
He's not stopping.
His life on the run came to an end. He ran several red lights before he was cornered in the parking lot of a children's hospital and used his car door as a barricade.
We want you to feel peaceful. We want you to do what I ask you to do, and you won't get hurt.
As negotiators tried to persuade King to surrender, a SWAT team moved in to surround him.
Get out! Keep your hands up! Stand up!
When he stood, King appeared to reach for a gun in his waistband. Bad move.
Don't reach! Hey, don't do it!
Oh! A hail of gunfire followed. King lay dead, still clutching his handgun. Cops say he had 11 weapons, along with fake uniforms, police badges, and ID from a phony federal agency.
Representative Crockett says it's incredibly alarming that an individual was able to circumvent the vetting process. She also says her team followed all federal protocols when it comes to hiring security.
What a shock that Jazzy Crockett, who adopted sort of a thug persona, would have a thug as a bodyguard. I'm absolutely shocked. Was that a good shooting or not, guys?
I liked it. If you can like something like that, I liked it.
Well, I mean, it was a lawful shooting.
Of course, he's got a gun in his hands as he's lying on the ground dead. So, yes, I would say that was 100% good.
I mean, they gave him every opportunity to give it up. I mean, they didn't start firing. I mean, they tried to get it out, give him up. So I can't see anything they did wrong.
The family of the deceased thug hires Dr. David Osborne to file a lawsuit. You got to come up with something. What are you going to claim?
We'd have to see all the evidence and investigate it. I mean, it's one of those things that just off that clip, I don't see it, but that doesn't mean that you wouldn't have 40, 60, 70, 100 hours into researching it to find something.
It's possible. You lawyers are clever.
Some are more than me, I think.
Right. All right. Well, thank you so much. It was a lot of fun having you hang out with us. It was longer than I expected. I thought it was going to be brief, but thank you for being a good sport and playing along. Do you feel we addressed all the important points about the Afroman trial before we say goodnight?
I think so. There's been so much information. I know people are going through the depositions. There is a lot of information out there that we filed that did not get presented in court, especially in the depositions, because all the stuff with the counterclaims was gone and judge was very specific. We're going to tailor it down. So you got to see a little bit of it, but most of it's in the depositions.
Okay. Yeah. I'm going to dig through a lot of these videos because everything I've seen so far has been both entertaining and interesting. So I have a feeling there's a few gems yet to be discovered. So those of you at home who might feel the same way, just go to YouTube and search Afroman, and you won't be disappointed. All right, so let's end tonight with about 9 minutes from our interview yesterday with David Carey. He's the managing legal director of the ACLU of Ohio, and we talked about this Afroman case with him. So let's give that a play now. Again, thank you, David, and thanks to our beloved audience. Oh, before we say goodbye, let me mention that tomorrow, usually we have Ask the Inspector with Scott Ritter at 7 p.m., but he is in Russia, so tomorrow we'll be on at 3 p.m., which I think is 10 p.m. local time for him in Russia. That's 3 p.m. tomorrow, Ask the Inspector, and you can submit your questions at ustourofduty.org. Okay, thanks again, everybody. Have a good night.
You have a nice night, guys.
Take care.
Carey is the managing legal director of the ACLU of Ohio, and he submitted an amicus brief in the Afroman case, officially called Sean D. Cooley et al. Versus Joseph Edgar Foreman, a.k.a. Afroman. Was it as fun and as amusing for you as it maybe was for the public?
It was fun. This subject matter is entertaining. Afroman's an entertaining guy. He's got a lot of, funny things to say. At the same time, it does touch on some very serious issues of free speech, of First Amendment law. There's really very little that the First Amendment protects more than the right of people to comment on public officials' actions. And that includes police officers. So, if you start picking apart his words and saying, this was phrased in a way that might sort of be a statement of fact or an opinion or, I'm not sure what, you're kind of missing the broader point. The broader point is that the kind of speech he was engaged in is critically important. It is why the First Amendment exists. If Afroman says something like that, does he mean it literally? That's what the jury is ultimately being asked to decide. Like, is he literally saying that this event transpired, that he slept with this officer's wife? Or is it more of just kind of a
talking trash, nobody takes it seriously kind of thing?
Exactly.
David, how could he not be prepared for that question? I mean, would his attorney have prepped him and say, this is probably what you're going to be asked during the course of your deposition?
It creates all sorts of bad karma to comment on the performance of other counsel, so I'll refrain.
Okay.
I will say that that is something that you would certainly expect that he would be prepared to testify about. Again,
it may not be the attorney's fault. It may be the attorney might have prepared him properly, but the cop was just too dumb to behave properly.
Any of these are possible. I could just say that you would think that if the heart of your claim is that someone is making a factual statement about you that is false and that has caused you pain, you better, even if you personally can't testify that it's false, you better have someone who can. So, if the officer can't testify personally that it was false, bring his wife in, put her on the stand. Someone's got to establish that it's false.
Now, he called one of the other cops a pedophile, too. So is
Yeah.
that the same thing, the motherfucker theory that we will now
Yeah,
call
the motherfucker theory.
yeah.
This is a case. Elon Musk had a similar case where he had called someone a pedophile or a pedo and was sued for defamation. And he prevailed as well under similar theory. It wasn't meant to be taken literally. It wasn't actually taken literally. That's not how people understood that to be. Everyone knew why, in the context of his videos, in the context of all the public discourse around this, everyone knew why Afroman was outraged at these police officers. In that context, it's very, very unlikely that anyone would take that as a specific allegation that someone engaged in some sort of pedophilia. Instead, it's much more likely that it would be taken as what it was, which is just a generic insult.
David, the thing with the pedophile, though, I mean, that I almost feel like almost does cross a line because it's a specific criminal act. You know what I'm saying? Like if you,
I got to go back to the motherfucker theory
I
again.
get it, but I mean that is
Yeah, but hardly anybody is fucking their mother, and that's a much more common insult than pedophile. I guess is sort of common, but
it can be. I mean, in different depends where you're coming from. Calling someone a pedo. Elon Musk testified about this. That's a term that he throws around. It's just different slang in different regions. There's a lot of leeway given to general insults like that. But to your point, Greg, I think the judge at least thought that was a close enough call that it should go to trial.
I don't know. That one just seems overly specific. With all the different.
Now I know how to get him riled up. I know what to call him when
I'm sure you have thoughts about JD Vance and couches as well.
Yeah.
Well,
but that one just seems like a more of an insult than a label. I don't know.
Yeah, I mean, and that's
an allegation, a criminal allegation.
That's why that wasn't kicked out on his face by the judge, because he looked at it and said, this might be in the range of arguably an assertion of fact. Accusing someone of something. So this is how our system works. We have a jury. Just folks who come in and they hear all the evidence and, setting aside all the legalities of it, they're given instructions on how, the guidelines within the law that they should follow. And one of the questions that they need to resolve is, was this a statement of fact or not? Was this accusing them of something specific, or was he speaking sort of figuratively and broadly? And obviously they decided it was the second one.
Yeah, that would be a hard no for me, but
Well, Afroman doesn't want you on the jury then.
Yeah, no, obviously, I'm saying like Samuel Jackson didn't make a career out of calling people pedos or pedos or whatever.
Right.
Well, actually, as common as it is to use that insult in social media, and I've seen it countless times, seriously, this is the first time I've ever heard it said out loud. And you said pedo, David. You said pedo or pedo.
I think I'm stealing that pronunciation from Musk. I think that's like a maybe South African or British or Australian,
I mean, since the word is pedophilia, I would have thought it's pedo, but
this is not my area of expertise. I have to.
Well, it sounds like it is actually. In the warrant, it said that there was in his basement a dungeon in which he keeps women locked there, forcing them to urinate and defecate in a bucket as punishment for upsetting or disobeying him. And it turned out this house didn't even have a basement, let alone a dungeon where people were defecating in a bucket and all that. Does this happen a lot where a confidential informant who maybe isn't at all reliable is the sole basis for a warrant getting executed?
I think it's the responsibility of the judge or the magistrate who issues the warrant to kind of filter out that kind of information. Probable cause, the standard that's required to issue most warrants, is not a hugely high standard, but there has to be some kind of credible information giving a specific reason to suspect some kind of wrongdoing. I'm not going to comment on the particular propriety of this one because I just don't know the full scenario of facts. I think it's right to start from a place of skepticism with confidential informants, sure.
David, my experience was always, even if you had a confidential informant, you had to show a successful track record. And if you did not have that, then you needed independent corroboration, either from a second unaffiliated informant or, physical surveillance or interviews of neighbors or something that was independent but corroborative of what was going on. And I don't see where it's there for this. I mean, usually someone who's trafficking in drugs, there's going to be foot traffic or vehicle traffic back and forth from the house. The thing with the sex dungeon thing, I mean, that's almost goes to an imminent emergency where you really don't have the luxury of taking some time to put together a warrant, but almost have to respond there almost as a 911 situation if the person actually is being held against their will. I just don't see how this warrant passed the review of a judge to get signed.
I share your skepticism. I don't have any particular insight to offer beyond that. It certainly seems like something that is a very strong claim. Sounds rather outlandish, and the most outrageous claims tend to require a lot of evidentiary support to be believed. But I just don't know what information was in front of this judge, and what was the basis of the issuance of the warrant.
Have you personally met Afroman?
To my great disappointment, no. But one can always hope.
There seems like there should be some sort of a party to celebrate this victory, and that you would be one of the invitees.
Hey, man, you said it. I don't know. Maybe my invitation got lost in the mail. Maybe it'll show up. We'll see.
Maybe it went up in smoke, so to speak.
Right. Yeah, exactly.
All right. Well, thanks a lot, David. I appreciate you taking the time to speak.
Sure. Thanks for having me.
Thank you, David.